Good morning, my lords. My name is Kamau Karori, Senior Counsel. I've been instructed to introduce my learned friend, Ms. Caroline Oduor, for the petition. Caroline Oduor for the petition.
I'm present, my lords.
Yeah, the petition. Appears for the first respondent.
I'm present.
Yes, for the first respondent. I had seen Mr. Bitter here. Oh yes, my learned friend, Mr. Bitter. Bitter. For the second respondent. That's the representation, so my lord. What's coming up, my lord, to mention is the petition. No, not the petition itself, which was certified and directed to be heard before this petition. Yes, the petition itself is dated the 10th of June 2025. Please note that the first respondent has filed a reply affidavit. We shall need now to file a further affidavit in this matter. Subject, my lord, to the directions you may give, we had agreed that we can file that further affidavit and also file our submissions all within a period of 21 days.
How many days?
21 days.
Yes. Are you saying
The second respondent has not filed anything. I'll let him speak for himself. Yes. Sorry? It's just a further affidavit filed by the first respondent.
No, I'm talking, you want to add something.
So we want to add a further affidavit in response to that.
Be careful in these matters not to create a certain impression. I have any. That said, my lord, I believe that this matter is not should be handled together with the other matters because it arises from more or less the same parties. And the court ought to consider the question of consolidation as opposed to hearing this in isolation.
Yes, my lord. We filed our reply affidavit.
We have no objection to petitioner filing a further affidavit. And my lord, it's also my heart together with the series that are already going before this court.
You support it can be done together.
Petitioner has filed a further affidavit. We will also require time to. We are praying that they also file it together with the submissions so that we also respond within 14 days. That's the way.
As regards the issue raised by the second respondent on consolidation, we would have no problem with the matters being heard together. No objection to that. However, we object to consolidation of the matters because the petition that has been filed does not relate to any of the specific issues and complaints that have been raised by the individual judges. So we don't want to get into that arena. It is a specific constitutional issues that have been raised that are dealt with independent of the merits or otherwise of the other issues that have been raised. We will be objecting to consolidation, but we are happy to proceed by way of the matters being heard together. But separate suits. Thank you.
The other matter, because also we have to get the views of the other advocate in this other matter. Yes. So you can hold it. Because
If it may please, Lordship, the matter coming today for hearing is by the first interested party, Mr. Nelson Harvey, counsel, who is hearing first, here with James Chepcoin and Alfonso Ward for the first petitioner. Appears with Ms. Mbero and Ms. Sepp for the second petitioner.
sorry, for the second petitioner, is it?
Lady Justice Hangi. Sixth and seventh interested parties. Third, fourth, fifth, sixth, and seventh interested parties. Ms. Mulwa is holding brief. Mr. Paul Nyamodi is appearing with Mr. Duncan Okach and Mr. Amutavi. Mr. Odhiambo Ndege is appearing for the 17th interested party.
That the feeder was opposed to consolidation of the matters, but we have no objection on the matters being heard together in the sense of the matters coming up for here. After you've heard the other parties, we don't have a problem with the feeder matters also being given a date when these other matters coming up for here. I'm saying we object to consolidation. I think I'd already indicated that. We don't have a problem if the matter is to be heard, because I know getting the bench together sometimes takes a bit of time, and sometimes some of the judges have to travel here. So we don't have a problem on the day the other matters are scheduled for hearing. This petition will also be heard, but as a separate matter. Yes,
Lords, the certification of these consolidated 7 petitions was specific. The directions from the CJ that they be heard by the 2 of you were specific. The 3 of you. There is no way another matter can be grafted onto it. I'm inept. I cannot comment about the feeder matter, whether it should be heard on the same day with this one. I can only say that the ordinance is consolidated.
It's like an advisory, which is not possible. That is why I'm saying the issues cannot be isolated from the findings of the court in the consolidated petition.
This petition is not based on the facts in the other cases at all. This petition is based on the fact of what is the consequence of the process that has been started by JAC. That's all. The case is dependent on the process initiated. It does not take a position regarding the issues that have been raised, the factual issues that have been raised by the parties. Its outcome is not dependent on the outcome of the issues that have been raised by individual judges regarding their cases. So this is a standalone petition. The outcome of the petition itself, the declarations that we are seeking from the court, are not intended to aid any of the parties in the litigation. So this is a standalone petition that should be dealt with on its merits, separate from the factual metrics in the other cases. So, my Lord, I don't agree that this case is dependent on the findings that are made by the court about the facts in the cases, in the consolidated cases. And that is why we are saying it can be dealt with separately and independently. The only reason why, my Lord, we are saying that we have no objection to the matter being heard on the same day as the others is because of the difficulty of getting the bench, the judges to come here on a separate day to just deal with this one petition. So it is because of that that we are agreeable to this matter being dealt with on the same day when you're dealing with the other matters. But it's not dependent on the outcome of the facts in the other cases at all.
Says prayer number 1, a declaration that the process initiated by the Judicial Service Commission that involves simultaneous consideration of petitions for the removal of more than 2 judges, 2 or possibly all of the Supreme Court judges is unconstitutional. This is a point. A declaration that the JSC's decision to initiate a process that entails consideration of an omnibus petition against 4 Supreme Court judges is unconstitutional. 7. A declaration that the first respondent acted ultra vires, the first respondent is JSC, in breach of its powers by unlawfully excluding or not involving the Chief Justice in convening and declarations in a meeting where the decision contained in the letters dated on the 7th January to all the judges. A declaration that the Judicial Service Commission acted ultra vires in its powers by unlawfully excluding the CJ and the Supreme Court representative from the meeting where decisions were. So they are tied. I don't understand how you will hear these matters isolated. And the court has the jurisdiction and the discretion to look at the things and to consolidate it.
A single judge, if this court can hear, even this court can hear, determine the issue. The court is aware of several other petitions that have been filed by judges, indicated by judges of the Supreme Court, supposed to be against judges of the Supreme Court, and have been, filed by judges of the Supreme Court, and have been certified as raising substantial questions of law, and referring to the Chief Justice, who has empaneled a bench of 3 judges to hear petitions. In that regard, since this petition raises similar issues and to avoid situation where the courts may issue contradicting decisions, the appropriate course to take is to refer this matter to the Honorable the Chief Justice for empaneling a bench to hear it. I don't know what you understand by that.
Well, my understanding of that is that it was available to the because this issue is raised before that.
Yes.
We have taken a consistent position that FIDA is not involved in the issues involving the individual judges. The facts of those cases, the merits of the complaints that have been filed, it is not involved. And so there is nothing we can participate in relation to those proceedings. But there are serious constitutional issues alone. But we also believe, my Lord, that because there are serious issues or complaints that have been raised that have been dealt with by this bench, it will resolve those factual metrics and the factual issues that have been raised in that case. We are not participating in those issues that have been raised and the facts that my learned friend refers to. But there are questions that we want the courts to deal with and to resolve that have nothing to do with the complaints or issues that have been raised in the other cases. And we do not want, my Lord, FIDA will not want to be drawn into the issues and conflicts and disputes between the parties on the merits or otherwise of the issues that have been raised in those cases. Ours is a standalone. It can proceed independent of what the other parties are fighting over on the facts in those cases. It is not dependent on the outcome of those facts. No, it's not. You can, my Lord, can deal with the questions that have been raised clearly and separately from the disputes that have been raised on the facts. Because how the JSC resolves the process it adopts when it receives the complaint, the consequences of how they deal with those complaints can be dealt with separate and independent from the individual complaints that have been raised by or against a judge. That's the point we are making. And so we don't want to be dragged into the issues and complaints that have been raised relating to individual judges. So that I think, Lord, is important to my clan because they do not represent the interest of any of the other parties in this litigation other than its own interests.
My Lords, I think he is the advocate for the petitioner. It is his case. You cannot be compelled to consolidate it with another one. And picking from what Justice Chacha-Mwita said, there is no possibility of conflicting decisions because you've already been empaneled to hear the 2 different matters. Mm-hmm. So I think the prudent course is to give directions in that matter of FIDA. And then we go on with what we have It's not
prudent for ourselves to give directions in another matter when you have a question concerning the composition of this bench. If Justice Chacha Mwita was concerned about the possibility of conflicting decisions, should we then wait for the outcome of your application before we give directions? And then I can also hear from senior counsel.
Oh yeah, I don't know what directions were expected on the feeder matter for today, but if it's not yet ripe for trial, then the only prudent course for you is to determine whether, as a constituted bench of 3, you can continue hearing this, and then you hold the feeder matter until such a time as you have determined your ability to continue hearing this. I don't think it will be lost in taking that course, bearing in mind that one is still at the preparatory stages of hearing.
Senior
By your brother Justice Luther, the Chief Justice has empaneled this bench for purposes of this application or this petition. As I understand it, my Lord, I was not aware there is an application that has come up before you for purposes of recusal. We ourselves will not be involved in that application. We will not make submissions on those issues because, as I said, we are not involved in the matters arising in those suits. But my Lord, I am aware that then there is a decision that this court will have to make regarding whether it will hear that application first and decide whether or not the bench will remain the same. But I don't think it will impact the suit that has been filed by FIDA. It will still be heard by this bench, irrespective of the outcome of the application that has been filed, because there is no application that has been made in relation to the FIDA petition as regards empanelment, and we are not objecting to the bench that has been empaneled to hear this particular petition.
Thank you.
From this other, if you look at even their prayers, what they are seeking, because they're not even against Supreme Court, they're trying to protect it through their petition. Now, this one, the decision, just tell them that you take action because of evidence which appears. What will be the essence of hearing? Let's take discuss maybe 20 minutes break. Then we come up with a decision. Yeah, then we come up with the position. Yeah. Numbers. Can we hear the petition? The application.
My Lord, I'm always very precise, but 10 minutes is too little to be sufficient for me to do justice. Maybe give me 15. I may manage within 10. Yeah, so that...
15 and the other?
What's before you is my motions dated 9th June 2025. I have filed submissions with respect to that motion. The submissions are dated 23rd of June 2025. There are 4 questions upon which we seek determination in this motion. On the first question, whether the petition filed by the first petitioner, Lady Justice Martha Kome, should be assigned to someone else. I mean, the bench to hear that petition should be a bench assigned by someone else other than the petitioner. It is not in dispute that the petitioner, Lady Justice Martha Kome, is the one who appointed this bench to hear this matter. The question arises whether a party to a petition, even if that party is the Chief Justice, can assign judges to hear a petition. The starting point in the case of Rigathi Gachagua versus the National Assembly. And in this decision, which we'll find at page 123 of the exhibits to the motion. This is what the Court of Appeal stated. So, what is to happen when the Chief Justice is, for whatever reason, absent physically or temporarily incapacitated, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party, or substantially relates to the office or person of the Chief Justice. Whereas the Court of Appeal did not give an answer to that question, the Court of Appeal affirmed that the decision in Leila Conchela, where Chief Justice David Maraga had delegated the duty of empaneling a bench of judges to hear, was the guiding factor. It is therefore our humble submission that being the first petition in this matter, the prudent course for the Chief Justice was to delegate the function of appointing judges to hear a petition to the Deputy Chief Justice. That answers question number 1. Question number 2, whether the rest of the other 6 petitions should be heard by judges other than those assigned by the first petitioner, Honorable Lady Justice Martha Kome. It is not in dispute that my Lords Honorable Justice Lawrence Mugambe and Honorable Justice Bahati Mumwe were both appointed to the office of judge in an interview presided over by the first petitioner, Lady Justice Martha Kome, as chair of the Judicial Service Commission. Of course, judges decide matters based upon facts and the law. There is no dispute about it. That notwithstanding, there's also no dispute that perception of impropriety ought not to be entertained where there is legitimate fear for the same. And the guiding case on this principle is Republic versus Sussex Justices. We have extracted it at paragraph 18 of our submissions. This is what the court said.
Where is it on the list number?
On the list of authorities, Sussex appears as authority number 9 on the list of band. In the submissions, we have extracted it at paragraph 18. This is what was said in Republic versus Sussex. But while that is so, a long line of cases shows that it is not merely for some importance, but it is for fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. It is therefore imperative to ask whether justice will be seen to have been done when two judges hearing the petition were judges appointed by the first petitioner. And this issue is not new. It has been the subject of litigation in other jurisdictions. In the case of the matter of the Chief Justice of Gibraltar, which we have extracted at paragraph 21 of our submissions, the case of, it appears as number 12 in our listed bundle of authorities. Intriguingly, the Chief Justice of Gibraltar in that matter was a judge of the High Court at one point in time here, Justice Schofield. Schofield faced a petition for his removal before the equivalent of the Judicial Service Commission in that country. What he did was to file a suit before the High Court, and in that country it's only High Court judges, and sought to stop the process for his removal. It was determined by the tribunal constituted to remove him with the affirmation of the Privy Council as follows. The tribunal was correct to hold that the action of the Chief Justice in bringing the judicial review proceedings constituted misbehavior. So it's our premise that it is misbehavior for the first petitioner, Honorable Lady Justice Martha Koome, to come before a court subordinate to her as the President of the Supreme Court and subordinate to her as the Chair of the Judicial Service Commission and seek relief before that court. It is even egregious for the first petitioner, Honorable Lady Justice Martha Koome, not to see the impropriety of empaneling a bench to hear the petition. Still on the Rigathi Gachagua case, which applies in that regard, the question is this: is the bench as constituted fit for purposes of the criteria set out in law for a paneling of a bench? This is what was stated in the Rigathi Gachagua case. That the following must be taken into consideration when empaneling a bench: the expertise and specialization in the relevant area of law of a judge, judicial seniority, And with tremendous respect, Marchers are mindful of BAT versus Rent Restriction Tribunal that any judge, whatever the age of appointment, is fit to hear the matter. These are the words of the Court of Appeal: judicial seniority and experience, the need for balance and diversity of perspectives, often achieved by selecting judges in varied legal philosophies, regional representation, or professional backgrounds, any prior involvement in related matters, the sensitivity of the case, and the corresponding need to uphold public confidence in the judiciary, avoidance of conflict of interest to ensure impartiality. My lords, FIDA have just been here. This bench is fully male. It's fully male. There's a problem. There's a problem. Where is the female gender in this bench? It doesn't meet the test set out in the Constitution and the Court of Appeal. Where is the consideration of judicial seniority? I handled Philomena Mwilu versus DPP, and all the 5 judges of the High Court empaneled to hear that matter were peers of the Deputy Chief Justice. They were peers, both in actual age and date of appointment to the bench. I handled Conchella. Again, all the 5 judges that were empaneled to hear that matter were peers in actual age and date of appointment to the bench. But fundamentally, the benches were balanced. There were 3 male and 2 female. They were fairly senior judges and other judges of recent appointment. And the Rigathi Gachagua case, the Court of Appeal emphasizes that the paneling of a bench of judges is not a lottery. It's not a mechanical exercise. It needs to take into account fundamental considerations. My lords, as I conclude, an application of this kind is one that we advocates never want to make. But we must make, because it is a requirement of the law that we need to make this application. I therefore humbly request that you return this file to the Chief Justice so that the Chief Justice can do the correct thing. 1, delegate the petition filed by herself to the Deputy Chief Justice to empanel a bench. 2, to empanel a bench to hear the rest of the 6 petitions in accordance with the principles set out by the Court of Appeal in the Rigathi Gachagua matter and in the Conchella matter. That is my humble request. I rest. Thank you.
Has to be taken from the perspective that the issue of the independence was arrived at. My Lord, if I may,
Yes, I confirm that we filed our submissions in support of the first interested parties application. However, we will not be highlighting, we will be adopting our written submissions as is.
The issue as to whether there was a Chief Justice not on the bench because she had an interest which any panel ignored. What I would like to say is that yes, but we filed a ground of opposition. Yes. And we filed a ground of opposition on 7 June 2025 and written submissions on 11 of July 2025 in opposition to the application. With respect to that, we would wish to say that the issue of whether the Chief Justice can empanel a bench on a matter where she has an interest was settled in application before my Lord Justice Mamuye on 11 April 2025. And Justice Mugambi on 25th April 2025, both of which were served on acknowledgement. And the court went into the issue and made a decision. And what you are being asked is the first issue I'd like to deal with, which is that the application is very secure. And that is because these matters had been decided and the only route available for us was either to apply for review or appeal, neither of which he has done. He cannot now come by way of requesting this court by an application to place the file before Justices Mulu and Justices Wome to deal with matters which allegedly are not important. That is number one. Number two, there is no distinction between these two petitions. They are all both concerned with the direction given by the registrar and the order of the Supreme Court, on which all the judges of Supreme Court are concerned. So to try and purport to make a distinction between them and say that in some only the Chief Justice has an interest, in others only the Deputy Chief Justice has a different an interest, is a distinction without any base. This J is a Rosanna has head should have directed the court. So it is on a representative capacity. And on the other, each of the individual judges have filed their own petitions. They're the same petition dealing with the same issue. And you cannot now, by this game of numbers, put one before the Chief Justice and the other before the DCJ and say they're being decided by people who have no interest, because they have interest in both of them, and they're dealing with the same issue. Yes. Yes. Yeah. Yes. Yeah. number number 3. Rigathi made it very clear that there are only 3 circumstances on which the constitutional power granted to the Chief Justice to empanel can be delegated. And that is found at paragraph 149 of the Rigathi decision, paragraph 150, and paragraph 152 deals directly with matters where the Chief Justice is directly involved in a matter. And he says, so what happens when the Chief Justice is, for whatever reason, absent physically or temporarily incapacitated, or when a matter certified as requiring empanelment relates to a matter where the Chief Justice is a party or substantially relates to the office of the person of the Chief Justice. In this day and age, we do not think the Chief Justice can be electronically absent for an inordinate long period of time, such that she cannot empanel a bench or give appropriate direction. And they go on, go further to say at paragraph 155 that the decision hinges on rationale that since the function of the Deputy Chief Justice are in the nature of General Deputy, then the holder can undertake any of the functions of the Chief Justice because the General Deputy executes all ordinary functions of the office. We agree, but add that the Deputy Chief Justice can only exercise the extraordinary constitutional administrative functions of Article 165.4 in the exceptional circumstances we have set out, and the existence of those circumstances must be demonstrable and communicated not just to parties in the dispute, but the public. And this was where the Chief Justice is temporarily incapacitated, or when she is absent on leave, or when something happens to her. The circumstances which are outlined in Section 5 of the Judicature Act, which are not in this case. So, it is beyond peradventure that this opportunity my lawyer is trying to seize is not available. It doesn't fall within those exceptions. Now, the next issue is, can DCJ empanel a bench in the circumstances of this case? In this case, you had made a decision on empanelment. You are being asked to review it without an application for review, and to go back and direct the Chief Justice to empanel another bench and DCJ to empanel. There is no provision for such an activity under the Constitution. Now, the issue, he has dealt with the issue of recusal, and is asking your lordships to recuse yourselves. One, because you issued a conservatory order in the first place. Secondly, that Justice Bahati Mwamuye and Lawrence Mugambi were appointed during the tenure of the Chief Justice in a constitutional body called the ASC, and therefore the implication is that everybody who has been appointed during that tenure is beholden to the Chief Justice and ought not to hear any matter she's involved in. And then third, that the empanelment did not consider diversity and regional balance. And lastly, that your lordship lacked specialization, seniority, and experience. But the Gachagua case did not purport to set up a standard under which the power granted to the Chief Justice can be exercised under Article 165.4. In fact, I will read the particular passage where they dealt with the issue And what they said is they were speculating on what may go into the Chief Justice's mind. What may go into the Chief Justice's mind when empaneling, not what she's required to do. They say at paragraph 133, they start on 133, that on his part, Mr. Nyamodi asserted that during empanelment, the Chief Justice does not receive submissions from the parties regarding which judges should be empaneled. That the decision on which judges to assign is made independently and without input from litigants, reflecting the administrative discretion of the Chief Justice. And then they said, we can think of some consideration that may weigh on the Chief Justice in appointing judges to an expanded bench. And that's when they go to expertise, specialization, diversity, and other issues. It was not a determination of what must be considered and is now being put to you. This case is completely different from what is expressed in the case of Sussex or in the case of Justice Caulfield in Gibraltar, where Justice Caulfield decided to sue an interior minister on a matter where he was the Chief Justice, and they thought that was something a judge should not do. Here, the Chief Justice is expressing her constitutional right to come to court when there is a violation, which is available not only to her, but to every other Kenyan. There is no requirement either under the Constitution or under any law that any bench of more than one judge must take into account the gender balance in its Constitution. In fact, there are many benches sitting from time to time. I appear in the Court of Appeal quite often, where there are only ladies. Are those benches illegal? And can you recuse yourself merely because you do not think that there is representation of gender or that diversity among communities in Kenya is not taken into account? I would like to refer you just to the authorities I wish your lordship to take into account. Lord, I first started with dealing with the issue of contract official, and on that I would like to refer you to the case of Rael Odinga and IABC, which is in my list of authorities. And you will find it at page 51 of my list of authorities, particularly paragraph 18 and 19. I would like also to refer you to Gachagua on the right of and discretion of the Chief Justice in empanelment, and refer you to paragraph 55. My Lord, I would also wish to say that the grounds which have been stated to you upon which you are required to recuse yourself are grounds which do not satisfy the threshold for recusal. And I would like to refer you to the case of Jasbir Singh Rai and Talochan Rai. You will find it at pages 111 and 158 of my list of authorities. And Gladys Boss Cholet versus JSC, pages 175, paragraph 27. This court cannot permit itself to be placed on unfounded basis or bias to disqualify itself, because there is nothing which is inimical to the rule of law as allowing allowing unsubstantiated application to undermine the functions of judicial proceedings. Here, you are being tagged with the fact that just you appointed and nobody else appointed except the GSE. You are therefore beholden to whoever is one of the presiding officers of GSE. Nothing can be so foreign in judicial proceedings as what is being claimed in this case. In conclusion, my humble submission is that the application is unmeritorious, speculative, and is a clear abuse of process. And requiring your lordship to follow a path which is contrary to the law, as there is no application for review for the decisions which have been made before you. And there is no application questioning the right of the Chief Justice to empanel under Article 164.5, which ought to have been made if the issue was now to impeach the right of the Chief Justice to have empaneled this particular bench. I would therefore humbly submit that the Lordship dismiss this application.
My name is Ms. Bet. I hold brief for Mr. Musangi for the second petition. Your Lordship, we filed grounds of opposition on the 2nd of July 2025 and also filed our submissions on the 3rd of July 2025. Your Lordship, I associate myself with the submissions by Mr. Oralo on the fact that the application before you is res judicata. The issues therein having already been determined, thus we submit that it offends the finality, the principle of finality in litigation. The substrata thereof having been fully determined by this honorable court, by one Justice Mugambi, in his ruling dated 25th of April 2025. Your Lordship, yes. Your Lordship, at paragraph 84 to 90 of the ruling by Justice Mugambi, the court decisively held that the Chief Justice is the only constitutional holder authorized to assign judges for such matter, and further affirmed the doctrine of necessity. This court expressly rejected the arguments that have now been recycled in the application that is before you. Secondly, Your Lordship, on the question of whether the empanelment by the Chief Justice is unconstitutional, where she's a party to the petition, this is our submission. Your Lordship, the assignment of judges is a constitutional obligation conferred to the Chief Justice in her institutional capacity. Your Lordship, we wish to bring to your attention the decision in Kenya Medical Research Institute versus Attorney General. The same is listed as authority number 3 and appears at pages 19 to 26 of the second petitioner's list of authorities. Your Lordship, in that decision, the court expressly stated that as opposed to similar functions that were found in the previous constitution, the power of empanelment granted under the current constitution is a constitutional mandate. It is hinged on a constitutional provision Article 165(4) of the Constitution. Your Lordship, in advancing this argument, the first interested party has made reference to the case of Yakub versus the Queen. Your Lordship, that decision is distinguishable from the present matter for the following reasons. In that case, the issue arose in the context of a judge exercising judicial authority in appointing a panel to hear an appeal against his own ruling. Your Lordship, by contrast, in the present case, the Chief Justice exercises administrative function under Article 165(4). The Chief Justice does not in any way participate in adjudication of the dispute. Your Lordship, the reliance on that decision is not necessary for reason that there is no lacuna in law on that issue, as the same is settled under Article 165(4) of the Constitution. On the issue of recusal, Your Lordship, we want to make reference to the decision of Justice Mugambi at paragraph 88 of the ruling. This is what the court said. It is therefore untenable to imagine that judges assigned to hear the matter by the Chief Justice are subject to her control, and that the Chief Justice will direct the outcome of the petition. Your Lordship, the court relied in the case of Gashuri versus Attorney General, the same is listed at paragraph 5, listed as authority number 5, and we wish to rely on that same decision, where the court said at paragraph 16, in that respect, any suggestion that this bench and indeed any other judge in this country cannot and should not hear this petition is not only strange, but also will cause an injustice. This is so because the effect of such a move would be that the petition cannot be heard, and that as a result, it would never be known whether an impugned decision violates the Constitution as well. Your Lordship, we submit that judges are not beholden to the Chief Justice. Their independence is constitutionally guaranteed under Article 160, and they're expected to decide matters solely based on the law and evidence presented. Your Lordship, the applicant's contention at paragraphs 31 and 34 of the affidavit that there is a likelihood of bias merely because the appointment was made by the current of some of the judges were made by the current Chief Justice is, with respect, misconceived and unconstitutionally unsustainable. The issuance of such letters is purely administrative, a function exercised by the Chief Justice in her institutional capacity. It is the JSC that recruits the judges, and it is not the Chief Justice in her personal capacity. To that end, Your Lordship, I wish to submit that under Article 166(b), 1b of the Constitution, all judges of the High Court are appointed in equal capacity and exercise the same judicial authority regardless of seniority or background. Your Lordships, there is no provision whatsoever in the Constitution or statute that accords greater adjudicative weight to any of the judges. None at all. We thus humbly submit, Your Lordships, that the application for recusal is wholly without merit and does not threshold that has been set out. We humbly pray for dismissal of the application with costs to the second petition.
I associate myself with the submission responded to file submissions at least 5. I'll also find this record. I wish to add does not demonstrate in which way does not indicate any cogent reasons to warrant the recusal of this bench from hearing these consolidated matters. The allegation that two of yourselves were appointed under the administrative capacity of the CJ then presiding over the JSC does not merit recusal of a judge. My lords, there is not shown to us or to yourself any factual basis which is evidence of an iota of possibility of bias on this bench. I think my learned friend Mr. Harvey did not speak to the facts when he said that my Lord Justice Mugambi and my Lord Justice Mamuya were appointed by the CJ. That is not a factual statement. Maybe, and it is granted, that the appointments were made by the JSC in a long process that we all know about, that was naturally by the fact that the CJ is the president of the Supreme Court and presides over the issues of the JSC. She happened to be the one presiding. It cannot be said, therefore, that the JSC appointing Lord Justices Mamoye and Mugambi was in any way under the control of the CJ. That is stretching our imagination rather too far. I move to the next issue, my Lord, and this is the fact of the request to have the DCJ empanel a bench to hear the matters in which the CJ has an interest, so to speak. What would be the distinction, we ask, my lords, because in these consolidated matters, the DCJ is herself a party. She is a petitioner. So how do we cut and piece together, in one hand, a request to have the DCJ appoint a bench, and on the other, have the CJ appoint a bench where she is not involved? The factual situation we are dealing with is that already these matters are consolidated, and there is no prayer for piercing them apart. They will be heard as one. So there is no factual distinction between the petitions. I don't want to go through the very able distinction established by my learned senior friend, Senior Counsel Oraro, on Gashagua and the other decision of Lena Conchela against the CJ. where it is averred that CJ then Maraga appointed, rather designated, the constitutional power that he held then to the DCJ to appoint a panel. First of all, we have no hesitation in saying, my lords, that in so doing, CJ David Maraga acted unconstitutionally. The power provided, donated by Article 165(4) belongs only to the CJ. It cannot be donated to any other party. And no court can direct the CJ on either who to appoint or how many members to appoint. The expanded bench would be 3, would be 7. But that power is the power in the hands and exercised only by the CJ. Under Gachagua, my lords, the Court of Appeal did not provide an exclusive consideration on empanelment. It is therefore a misreading of Gachagua to say that the Court of Appeal spoke of gender, philosophy, seniority. Only Harvey can stand before a bench of Mwamuye and Mugambi, look them in the face and say, you are not senior enough to hear this matter. Of course, that can't be right. You cannot tell a bench of eminent judges that simply because they were appointed only a short while ago, that they don't have the judicial finesse, knowledge, competence to make a decision on a matter of this nature. I think he said it in jest. My lord, the act of empanelment is not a judicial decision, it's an administrative decision, which the CJ exercises with no control whatsoever on the ruling judgment that flows out of the considerations that the bench makes of the matter. Her role stops at only empaneling the bench. It's not being said before you that by appointing Justice Mugambi and my Lord Justice Mwamuye, she is going to call them and say, hey, listen, you were appointed as judges under my tenure, make this sort of ruling. It's not being said. And it cannot be. We all know that judges in the individual capacity make decisions, and those decisions cannot be gainsaid just because of the timing of the appointment of the judges. So I come to the last point I want to make, and that is whether this application is res. In the framing of it and in the arguments, sounds to me like an application for review. Because we are all aware that this issue as to empanelment, numbers, names, has already been made. My lords, on the 25th of April, my Lord Justice Mugambi delivered a ruling on this matter. and so did Justice Mwamuye at some stage. There's nothing new you're being told to rule upon, because we already know that those decisions have not been appealed from, and this fresh application is only but an attempt to review the decisions already made on this matter. What do I then say of this application of 9th June? My lords, I say that this application cries for dismissal and so grant a dismissal of this application with costs to my client, the third respondent. Unless my lords have a question, I will pause here.
Judge should hear that decision, that complaint, because the president appoints all the judges. The fact of the matter is that it's the judicial service that interviews, recommends, the president appoints, and all those parties, including the Judicial Service Commission, the chairperson of the Judicial Service Commission, the president himself, they will end up in these courts, and the judges will render justice because they have one overriding principle that guide their work, which is without fear or favor. Finally, the application by the first interested party has a dangerous ring to it, because if you were to accede to it, then you will judicialize, if you allow me to use that term, politics. Because to recuse yourself from a matter, or to be asked to recuse yourself, is to be asked not to be a judge, not to exercise your duty as a judge. And this is said that there is nothing else you do other than to judge. So if you're being asked to recuse yourself and you accede to it easily, then every person who appears before you, if they don't like the shape of your nose, if they don't like the color of your hair, they don't like your age, they don't like how you conduct your court proceeding, they will be telling you to recuse yourself. And this particular application will be cited as precedent. Now, in Sharia Mtaani versus Judicial Service Commission, the court was emphatic that if I allow the application, it would mean that many other judges, including those that were appointed pre-2022, will not be able to sit and hear the petitioner's grievances, as the time frame of his grievance is much wider. Judges have a duty to sit, and it is in the interest of justice that I prevent an unwarranted crisis in the administration of justice that may have the ripple effect of knocking out many more judges from the matter and the views of the petition. So basically, recusal is an exception, and it has to be met with compassion. Compassion because you're telling the judge basically to stop being a judge, and you're saying they're unfit to judge. Now, on specious arguments that have been made before you, that is not the situation. So we ask you to dismiss the application. It costs, because I know that was the prayer of Mr. Harvey, that we all get some fees. And we proceed to the petition. Thank you, unless you have a question.
Lordships, we have filed our grounds of opposition to the application. They are dated the 18th of June 2025. We have equally filed our submissions in opposition to the application. They are dated the 3rd of July 2025. We have equally filed our list of authorities. That is the 3rd of July 2025. It's only one authority, the Gachagua case, that we have relied on. First of all, as part of my submissions, I want to associate myself with the submissions that have been made by my able seniors for the first petitioner all the way to the sixth petitioner. Your Lordship, you are being called upon to interrogate the constitutional mandate of the Chief Justice under Article 165(4). But looking at the application that is before you, the applicant equally concedes that that particular mandate falls squarely with the Chief Justice. I will direct the court to ground number 11 in the said application. Further, you're being called upon to interrogate the question on whether the Chief Justice can delegate this particular mandate to the Deputy Chief Justice. Now, what the applicant is calling upon the court, looking at one of the prayers, is that the Deputy Chief Justice to empanel a bench that will hear and determine the petition that has been filed by the Chief Justice, that is number 083 of 2025, while the Chief Justice can empanel another bench to listen to the other 6 petitions. Your Honor, this petition has been consolidated. If you were to toy with the idea that the applicant is seeking before you, what if that order is granted? That is the question. What if the Deputy Chief Justice decides to empanel a bench of 5? And the Chief Justice decides to empanel a bench of 3? Does this petition stand consolidated? And how will the hearings proceed? Further, Your Lordships, when it comes to delegation of this mandate under Article 165, I believe the Judicature Act under Section 5(4) sets out the instances where this can happen. Looking at the application, Your Lordships, this has not been demonstrated in terms of what the law provides. Your Lordship, and it's a good thing that my senior Mr. Kemboy has referred to the Gachagua petition, and again I would like to refer the court to paragraph 213 in the Gachagua case, where the court specifically noted that the power to empanel a bench is a power solely granted to the Chief Justice. Your Lordships, the Chief Justice has already carried out her mandate, and that is why we are before you here today. Further, Your Lordships, you're being told that there are certain considerations that should have been taken into account by the Chief Justice when she was empaneling this bench. Again, Your Lordships, in line with paragraph 213 in the Gachagua case, the Court of Appeal said that it is the Chief Justice and she alone who can decide the number of judges to assign in a matter. Similarly, it is only the Chief Justice who can decide which judge to assign to a bench. Lordship, you're not being informed how, under Article 165.4, the Chief Justice has acted unconstitutionally. The guidelines given by a court cannot supersede the provisions of the Constitution. Secondly, Your Lordships, the applicant calls for your recusal in the matter. The JSC regulations, I believe, gives a guideline in terms of a recusal of a judge. Regulation 25 is quite clear in terms of the circumstances that might call a judge to recuse themselves from a matter. Looking at the application that is before you, no plausible reason has been placed before you to even consider your recusal in the matter. Your Lordships, again, I would like to refer you to the Gachagua case where the court in depth dealt with the issue of recusal. I would like to refer the court from paragraph 185 to 198. And I would like to add, in this particular case, the applicants actually went in depth and were very particular in terms of the allegations they were raising before the two judges who they would have wanted to recuse themselves in the matter. Ultimately, the court dismissed that particular application and did not find merit in the allegations that were leveled before the court. I believe the submissions that we have filed on record deals with the other issues. I will not belabor the points, Your Lordship, unless you have any questions for me.
We do not support the motion for recusal. Your Lordship, the court, the bench as currently empaneled, did not empanel itself. And that fact, that empanelment is not attributable to the Lordships, means that cannot be a basis for your recusal. It was not your action. And then finally, my Lord, my understanding was that this was an application for recusal. But hearing the submissions by counsel, it appears to be an application for judicial review. Which jurisdiction? It is my respectful submission, you do not have. Because you would require a substantive suit seeking judicial review orders in respect to the decision of the Chief Justice. You cannot, in an interlocutory application, ask this one. My Lord, when a party questions the exercise of a public power, they can only do it by way of a judicial review application. Either petition or a suit, not an interlocutory motion like this one. So I doubt, and it is my submissions, that you lack the jurisdiction to exercise a judicial review function in respect to the administrative decision of the Chief Justice. Okay.
In position, this application, the first respondent was yes. Mrs. Ahomokalez. Will not be taking a position and will leave it entirely to the court.
Malizo Nyawa.
Yes.
Katiba Institute. My lords, the advantage of speaking last is that I can adopt all that which has already been said. So I will show from my seniors.
In which side?
The side of
Petitioners.
we are opposed to the application. Yes,
Okay.
that's what
Okay.
And our submissions are dated the 2nd of July. Second of July 2025. In addition to what has been said, I'll make 3 quick points. One is that
And once the pleadings have been filed, council cannot orally amend those pleadings. The application dated the 9th of June 2025, it only had one ground of bias. Then 9th of June 2025, it was only based on the ground of bias on the Chief Justice. It was not about gender of the bench, neither was it about the seniority of the judges on the bench. As such, my lords, senior Harvey cannot amend that application orally in court to recall resolution. The second point, my lord, is what Senior Peter has submitted on. That if Harvey wants to challenge the constitutionality of this bench, she needs to file a judicial review application or a petition to challenge the constitutionality of that administrative action of the Chief Justice. This is because, my lord, the grounds for recusal as provided for under Regulation 21 of the JSC Code of Ethics 2020, the grounds are listed, and it does not include the gender of the bench or the seniority of the bench. We submit, my lord, that those are considerations of a constitutional petition or judicial review of that administrative action and not an application for recusal. The second point, my lords, is on the ground of res judicata. And the point, my lord, that we seek to submit on is Justice Mamuye and Justice Mungambi made individual opinions or decisions. They are judges of the High Court of Kenya. A bench of 3, a bench of 5 cannot review that decision. The High Court, my lord, in Philip Tunoi and another versus the Judicial Service Commission, it is our authority number 6. It says that, my lord, that a numerically superior bench does not have more powers than a single judge bench. They are all equal. And as such, my lords, the position that was held by Justice Mamuye and Justice Mungambi cannot be brought before you again. That can only be appealed, my lords. That, my lords, is the prayer that you referred these petitions to the Chief Justice, with a direction that she sends some to the Deputy Chief Justice. My lords, Justice Mungambi made an order consolidating the petitions.
once that order is in place, unless it is appealed, those petitions cannot be submitted separately again. So Senior Harvey must first start by appealing that consolidation ruling first. And if he succeeds in that, then now he can seek the separate forwarding of those petitions. And lastly, my lord, on the prayer for recusal, my lord, we submit that our recusal application, my lord, it should be a shield for safeguarding the administration of justice, and it should never be a sword. In this case, my lord, the recusal application is being used as a sword and not a shield for the safeguarding of the administration of justice. It cannot be, my lord, that judges should recuse themselves because they were appointed by a JSC that the Chief Justice was part of. If that, my lord, it was the case, then JSC would have won all cases in courts. And my lord, in my 2 years, the JSC has lost 5 petitions. So my lord, it cannot be a ground that just because the CJ participated, then this bench is to be biased. And also, my lord, judges take an oath of office and uphold the duty to serve, my lord. And if this bench, my lord, it will consider other extraneous facts, then there is a limit for that. People can go to the JSC or they can appeal. But it cannot be that judges should just recuse themselves on that basis alone. On the Gachagua decision, my lord, it is our position that it does not support the position taken by Minister Ham. First, my lord, the first finding of that decision was that it is only the Chief Justice who can empanel a bench. That was the finding of the court. Then the court proceeds to hold that there might be considerations when that Chief Justice is not available. But here the Chief Justice is available. And Article 165, sub-Article 4, my lord, it rests that function singularly on the Chief Justice. At my lord, the application this application is best. I said I have an advantage. I know to do this best. I also know the petition.
When confronted with fear. When confronted with fear, you either fight or take flight. I've decided not to take flight, but to fight, knowing very well what my eventuality might be. So, without introduction, let me traverse what my colleagues have put as points of law. Starting with my learned senior and good friend, Mr. Oraro, it is true that the decision for empanelment by Justice Bahati Mumwe was made on 11th of April. And the one by Justice Lawrence Mugambi was made on the 25th of April. He is of the view that I ought to have appealed or reviewed. I'm always very mindful of what President Ronald Reagan said. Those in charge of the system will tell you follow the laid down procedures. In my short life here on earth, I don't follow laid down procedures because I know who are in charge of the systems. But fundamentally, Rigathi Gachagua was decided on the 9th of May 2025. It is the operative law. And it has said where the Chief Justice is a party to a litigation or is substantially affected in litigation, it will be prudent that he or she does not empanel a bench. And this is not said from the emptiness of my head. It is stated from the wisdom of the case of Yakub and another versus the Queen, which you will find at paragraph 22 of my submissions. It's quite clear. And in that case, the Privy Council said it was wrong for Yakub to empanel a bench to hear an appeal from his decision. So if it was wrong for Yakub to empanel a bench to hear an appeal from his decision, it is grievously wrong for Martha Koome to empanel a bench to hear her own case. I fear. My learned friend, Mr. George Oraro, stated that it will be inconsistent for part of this petition to be delegated to the Deputy Chief Justice and part of it to remain with the Chief Justice for purposes of empanelment because they are conjoined. Yes, they are indeed conjoined. But whose problem is that? It was not the expectation of the drafters of the Constitution that the Chief Justice and judges will be embroiled in litigation with mere mortals like Nelson Harvey, who do not have prefixes before their names. My colleague, Madam Bett, stated that this application is res judicata and offends the principle of finality. She proceeded to read the decisions by Honorable Justice Bahati Mumwe and Honorable Justice Lawrence Mugambi to indicate what they had determined. That is why I fear. And you say, my Lord, as you consider my fear vis-a-vis the favor I posit will inure to the benefit of the CJ and the other judges, take this into account. None of these 7 judges have filed a replying affidavit to controvert my fears. None. I may be wrong in my fears. I'm entitled to be wrong. But nobody has assuaged my fear.
My Lord, I would hate to interrupt, but I think he's made a statement that is not correct. There is a replying affidavit to his application.
Oh, Isaac Lenard? Yes. He said he's suing me. Anyway, fine. That's okay. That's why I fear him.
Well, that's my client. I don't want to interject because
He's also my friend. We eat and drink with him, so just relax.
I
I'll be done in 5 minutes. My lord, you know, and I need the youthful advocates to learn. You needed to have listened to Richard Otieno Kwach and Dr. Hamino present the case of SM Otieno. This is what we are trained to do, to speak. So let me just conclude with the precision. Keboi also said that if my fear was to be countenanced as legitimate, then the president who appoints judges before this Commonwealth in Kenya should have the greatest fear. I've sat with the president I can tell you without any fear of contrition, he fears. But the fact of the matter is this: the president does not appoint judges. He just swears them in. Judges are recommended for appointment and appointed by the Judicial Service Commission. Another person who receives a lot of favor is the Attorney General. He will come to court, no replying affidavit, no grounds of opposition, no submissions, but he'll still be heard. That's the reason why I fear most. We're not equals. My very good friend Joshua Malizu, I'm very happy to see you and meet you in person, finally. He has said, my application, for all practical purposes, is a judicial review application. He has also said, if my fears were legitimate, the Judicial Service Commission should fear most, because as the one that recommends for appointment, it still loses all cases in court. Now, that premise is not correct. The Judicial Service Commission loses most cases in court because the cases are filed by judges or magistrates, not by the Judicial Service Commission. Again, this is not a judicial review application, and it ought not to be one. This is an application to recuse the bench empaneled by the Chief Justice, who is the first petitioner, so that the Chief Justice can do the correct thing. Again, I humbly request, I'm not saying you allow my application because I know you'll dismiss it. I humbly request that you do the right thing. I'm also glad.
Did you agree time and virtual?
10:30 a.m. I said it open court.
10:30 virtual.
I said it open court.
You do it virtual.
The permissions we have, we decided that the ruling will be delivered on 14th November at 10:30 here in open court.
Most obliged. Thank you so much.
Have a good day.